In our criminal law video series, we've covered quite a number of different aspects, particularly to do with elements of criminal liability. We've spoken about the act as a basis for criminal liability, where we said there should be a voluntary human act. We have spoken about other elements too, so let's see what today's edition has got to offer. By the end of this lecture, you should be able to define the concept of culpability, illustrate the significance of criminal capacity as an indispensable component of culpability. You should be able to demonstrate the relationship between criminal capacity and other elements of culpability, such as intention and negligence. Then you should describe the influence of Section 78 of the Criminal Procedure Act 51 of 1977 on the formulation of the pathological criminal incapacity as one of the defenses that exclude culpability. Then you should identify and explain the two legs of the pathological criminal capacity, rather criminal incapacity, in terms of Section 78. You should be able to describe the role of the different forms of pathological criminal incapacity and then explain the roles of dolus and culpa, in the determination of criminal culpability. Last but not least, you should be able to evaluate the relevance of strict liability crimes against the backdrop of the Constitution, that's Section 35(3)(h) of South Africa 1996. That is looking at them against the backdrop of the principle of presumption of innocence. As I alluded to earlier on, there are four elements of criminal liability in terms of South African law. We have our first one is the voluntary human act of omission, and then we said that that's a prerequisite element, that's a starting point. If there is a voluntary human act of omission, then we go on to look at whether that act accords with the definitional elements of a particular crime, depending on whether it's a result crime or it's a formally defined crime. And then we went on to look at the element called unlawfulness, as well as the factors that can exclude unlawfulness. And then this particular video is looking at culpability, everything to do with culpability. Just pay attention, because this is the last leg out of these four elements of criminal liability. If you have missed the other videos, please make sure that you look for them, because in order to have a complete story, you must actually hear all of them and watch all of them. Just maybe as a point of departure, let us explain what we mean by culpability, which is sometimes referred to as fault. We are saying culpability is an integral element of liability. There cannot be any liability unless there is a fault. So in other words, you can't hold anyone liable in law unless you have satisfied the expectation that their conduct is culpable. In other words, their conduct brings them at fault. We'll explain a little more about this aspect of fault, but we are saying a principle generally exposed. This principle is generally exposed or expressed in the Latin maxim actus non facit reum nisi mens et rea, which basically means the act is not wrongful unless the mind is guilty. So in order to convict somebody of a crime, it is very essential that the fault or the guilt of the mind must be established. What do we mean exactly by culpability, or this mens rea that we are talking about? It is the blameworthy state of the human mind or the mind of the accused. So you find that when a person commits an act, what is called the actus reus, and it turns out that that act conforms to the definitional elements of a crime, that is still not sufficient to found or to establish criminal liability. Culpability emanates from the grounds upon which the act committed by X is reproachable in the eyes of the law. On what grounds does the law look at somebody's act and conclude that the act or the conduct or the omission actually deserves to be punished because it is bad, it is reproachable? So that reproachability of an act or human act or conduct establishes its culpability. So as I have already highlighted, culpability means fault, it means blameworthiness. So when a person who has criminal capacity acts with either intention or negligence, fault or culpability, culpability is established. So we are now bringing in another aspect here, the one of criminal capacity. And we are saying that the criminal capacity of the perpetrator or the accused is essential for the determination of their culpability. So the law does not attach blame or fault to an infant or an insane person. In other words, it is only those who are endowed with criminal capacity, which is a form of the state of the mental state. I've given examples there of infants and insane persons. We will explain later that these people do not have they don't have the ability to appreciate the wrongfulness of their act or conduct, and sometimes even when they do appreciate the wrongfulness of their act or conduct, they still can't act in line with that appreciation. So hence we are saying that the law does not attach any blame to an infant or to an insane person or to anybody of a limited mental capacity. So a patron of a gym who mistakenly picks up a jacket of another patron at the end of the training session because it is similar to his own and believes that it is his own, that kind of a patron is not liable for theft, as he did not possess the requisite blameworthy mind. Common law crimes have either intention or negligence as their basis of culpability in terms of the definition of proscription. And we are saying that there is always a presumption of statutory interpretation that the legislature intended some fault in the formulation of the statute. So it is very essential to always remember that culpability is expected, or rather must be proven by the prosecution or the state in respect of any crime or any prosecution that is being undertaken. So you find that culpability relates with unlawfulness in a way. And we are saying that an inquiry into culpability is preceded by the establishment of unlawfulness. In other words, in the process of inquiry into the culpability of the accused, the first point that must be established is whether the conduct that is attributable to the accused is actually unlawful or fulfills the requirements for unlawfulness. For a further clarification on what we mean by unlawfulness, please look out for the video that deals with the unlawfulness. Suffice it to say that it is absurd to attach fault to lawful conduct. And we are saying unlawfulness is objectively determined on every actor, regardless of their mental state, their social status, or whether rich or poor, young or old. So if an act is unlawful, it doesn't matter who has committed it. In inquiring about the unlawfulness rather of an act, we are not concerned about the subjective circumstances or the subjective traits and qualities of the perpetrator. We are only looking at the act itself, whether it conforms to the elements of lawfulness, the characteristics of lawfulness as one of the elements rather. So unlawfulness is excluded by the presence of the grounds of justification. Remember, we spoke about different grounds upon which unlawfulness can be excluded. Speaking, of course, about private defense as one of those grounds. Speaking also about necessity as one of the grounds. And speaking also about how mistake can actually sometimes eliminate lawfulness, rather unlawfulness of an act, thus rendering what would putatively be an unlawful act as lawful and permissible, or tolerable at least within the context of the law. Culpability is excluded by lack of the requisite mental capacity to appreciate the wrongfulness of one's act, e.g. A mistake. So it's very, very important just to look again at what we mean by the distinction between unlawfulness and culpability, because those are two legs of the inquiry on criminal liability, but they are not one and the same thing. So they are complementary, but they are not one and the same thing, and you should not conflate the two. So talking about criminal capacity and culpability, you find that criminal capacity or mental capacity is a very essential prerequisite of culpability. Only those who are endowed with a sound mental capacity can be held liable, can be found to have a blameworthy state of mind. We mentioned earlier on that the insane people, as well as the infants or minors, maybe those, including also those who are provoked, who act in anger and so on, they tend to have a diminished mental capacity, so the law does not punish their conduct. And we are saying criminal capacity is the mental ability required for one to be held liable for a crime. And mental capacity means the ability to appreciate the wrongfulness of one's action, as well as the ability to act according to the appreciation of that wrongfulness. We give an example of a child or a mentally sick person who may not appreciate, or even after appreciation still can't act according to their appreciation of the wrongfulness. So a child may do something which is harmful to others. We are talking maybe about minor children, especially those below the age of 7, who can't have a proper appreciation of the wrongfulness of what they do. And even if they do, in some instances, realize that they've done something wrong, they still don't have the power to resist the urge to go ahead and do whatever their whims and their caprices are pushing them to do. So we are talking here about what the Rumpf Commission of Inquiry in 1967 described as the cognitive as well as the cognitive power that a perpetrator is endowed with. By the cognitive, we are speaking about the intellect, or the power to reason things out. And then the cognitive leg is, the power to resist, that power to exercise self-control. So we are saying somebody may appreciate that their conduct is wrong, but maybe they may lack the power to exercise, that self-restraint and self-control. So we are saying that in assessing the culpability of a person, we look at their mental capacity in terms of whether cognitively they have the power to appreciate the wrongfulness of what they are doing or they have done. In fact, what they are doing, because again, there's the principle of contemporaneity, where we are saying the power to appreciate must occur at the same time as the commission of the act concerned. So the power to appreciate and the power to resist. Having established that criminal capacity, in other words, when an inquiry is being conducted, the prosecution must lead the court towards the establishment of the criminal capacity of the accused. And then once that is done, then there's an inquiry into whether the accused acted with intention, which is called dolus, or acted negligently, which is called culpa. So the intention and the negligence are two forms of culpability. And culpability and unlawfulness must occur. I've already pointed that out contemporaneously. In other words, at the time when the act or the conduct is being undertaken, the blameworthy state of the mind must be present at that time. In other words, we can't have somebody who says they appreciated the wrongfulness of the act earlier, but at the time of the commission they did not, because then that would prove that at the moment the offense or the act was conducted, there was no proper appreciation of the wrongfulness. We will see this clearly when we look at those who are mentally ill, those who used to be derogatorily referred to as insane. A person who is a mental patient is not always unable to appreciate the wrongfulness of their wrong actions. Sometimes there are those moments which are called the lucid valam period or phase, where the person is sane in every respect. And then you find that these bouts of illness or insanity show up from time to time. So we are concerned, when we look at the wrongfulness of their act, we are not concerned about the general state of their health, but we are looking at what the state of their health was specifically at the time when the act was committed. That could have been maybe a period of lucid interval where you find that the person was not exactly in that bad frame of mind. So it's very important to establish whether specifically at the time there was a problem. And we are saying, in order to establish culpability, the two forms of culpability after establishing criminal capacity are intention and negligence. We will give them a little more attention later on. And we are saying culpability and unlawfulness must occur contemporaneously. I think I have belabored that point many times so far. So thinking in terms of criminal capacity and intention, you must take note that criminal capacity is the foundation or the prerequisite for culpability. So you can't go on to inquire whether the person acted with intention or negligence unless it has been established that they possessed sufficient or a sound mental state to be able to appreciate the wrongfulness of their act, as well as to act according to the wrongfulness of their act. So it is only the intention or the negligence of a person endowed with the criminal capacity which justifies an attribution of culpability. So unless it is fully established that the accused person possessed criminal capacity at the time of the commission of the act, there is no point in inquiring into whether they acted negligently or intentionally, because that would not be a worthwhile effort or endeavor. It would not add any value. And we are saying capacity inquires into the mental abilities of the perpetrator. Were they able to appreciate the wrongfulness of their act? And were they able to, having made the appreciation, act in accordance with the appreciation? So intention and negligence must inquire into the presence of a certain mental attitude. That's what happens. So unlawfulness inquires into the act itself. Criminal capacity inquires into the frame of mind of the perpetrator, whilst intention looks at their attitude. So the frame of mind is one element to say, were they sane, were they mature enough, did they possess the requisite intelligence to appreciate the wrongfulness of their act? But intention is a question of the mental attitude. What was the attitude of the perpetrator? Did they will? Was it their will to carry out the act that they eventually did carry out? So those are the questions that need to be answered. So there are certain defenses that one may have to invoke regarding criminal capacity. So an accused may escape liability. They may escape culpability, liability based on culpability, on the strength of, the fact that they were mentally ill. They were laboring under a kind of a mental illness called insanity in pejorative terms. And this is covered in section 78(1) of the Criminal Procedure Act 51 of 1977. It is a form of a pathological criminal incapacity. We will look at the distinction between the pathological and the non-pathological incapacity. So that's the first point, the mental state. If we are dealing with a mental patient, then they may lack the requisite criminal capacity. Or youthfulness, young people, children particularly, lack criminal capacity. And then there is the general defense of criminal incapacity, which an accused may plead. We will look at this in detail so that we clarify what we are talking about. So mental illness as a starting point. We have already indicated that section 78 of the criminal procedure deals with this subject. You find that until its adoption in 1977, the issue of mental illness has been dealt with under, in terms of the English law rules of what is called the Magna rule. So the 1977 Act first brought the subject of mental illness under statutory regulation in South Africa. And we said that it was because, in fact, it was influenced by the Rump Commission report of 1967. So the inclusion of mental illness in the statute was an implementation, of course, of the Rump report. Maybe let me just give a little bit of detail on this Rump report. It was a report of the Commission of Inquiry into the Responsibility of Mentally Deranged Persons and Related Matters. As I have said, that was 1967. So mental illness then ceased to be dealt with on the basis of Magna rules of English law. And just a look at section 78, it states that a person who commits an act or makes an omission which constitutes an offense, and who at the time of such commission or omission suffers from a mental illness or mental defect, which makes him or her incapable of appreciating the wrongfulness of his or her act or omission, or acting in accordance with the appreciation of the wrongfulness of his or her act or omission, shall not be criminally responsible for such act or omission. Remember, I have spoken at length about the two-leg inquiry of criminal capacity, where we said first there is appreciation of the wrongfulness of one's act, which we said was the cognitive element, and then secondly we said there is the issue of acting in accordance with that appreciation, which we said was the cognitive element. So the cognitive element is the one that links up with self-control, or the ability to, resist whatever may be seeking to overcome you in terms of, the urge to do wrong. And we are saying, so basically there are two legs of the mental illness, and two legs of the mental illness test, where we are looking at the cognitive and the cognitive abilities. And then take note that the onus of proof of mental illness rests on the accused. It is the accused who brings up the idea, brings up a proposition before the court, that at the time of the commission of the act, he or she was not in the right frame of mind. So there must be proof. But usually when such is done, then when such a plea is advanced or presented, then the expert opinion evidence from the medical, or rather psychiatric doctors, is then required in order to substantiate that claim. And the verdict of a successful plea of mental illness is not guilty, and that is in terms of section 786. But an order for detention in a psychiatric hospital or a prison immediately follows. So when an accused claims that at the commission of the act, he or she was not in the right, or rather he did not possess criminal capacity, then an inquiry will be made and confirmed by psychiatric evidence, but then the accused will not be acquitted. He will then, of course, it's not guilty, because culpability, or rather the fault, cannot be attributed to him or her, but still doesn't go home. It goes to a mental hospital, or a psychiatric hospital, or even a prison. So that is the effect. And the act, that's the Criminal Procedure Act 51 of 1977, starting from section 77, 78 and 79, there is a coverage there of different forms of illness, including diminished responsibility, intellectual disability, and so on. So those are the different terms that are used. Just take a look at that section and familiarize yourself with them. We have mentioned the element of youth as one of those factors that are very significant in terms of, excluding culpability. When somebody is youthful and young, to the point that they cannot fully appreciate the consequences of their conduct, then fault is not imputed upon them, as we have already said. One of the most important, if I would say, defenses in the case of criminal capacity is what is called non-pathological criminal incapacity. This refers to the commission of an act which conforms with the definitional elements of a crime, but still there may not be enough to establish liability. Maybe because the person lacked the criminal capacity. And because we are saying it's non-pathological, it is not based on an illness, but it is based on the state of mind of the accused at the particular time. So we are saying culpability can be excluded by non-pathological criminal incapacity. And this was first expounded by the Court of Appeal in the Lobska 1988 case. We are saying it is a common law defense which excludes criminal capacity based on, non-pathological causes. What do we mean by the pathological causes? We are talking about sickness, disease, or a pathological disturbance of some kind. So this non-pathological criminal incapacity is caused by factors such as mental collapse, emotional collapse, mental stress, total disintegration of personality, shock, fear, tension, mental exhaustion, intoxication, and provocation. This defense must satisfy two legs. Again, we're talking about the cognitive and the quantitative legs, which we discussed in respect of the mental insanity, or rather mental illness cases under Section 78. And so we are saying, the precedent, we have the Kempfer case of 1987, that is the matter on the Dove Court, where a wife killed a husband. I think if you follow up on that case, you will understand the torture and the frustration that the woman had been facing at the hands of her husband until she eventually killed him. And the court established that though she had acted unlawfully, but culpability was lacking because of the nature of the treatment and the relationship that they had, and so on and so forth. Another case of Weed 1990 also had a woman killing her husband under circumstances of a strained relationship and frustration. Take note that the onus of proof when the accused raises this non-pathological criminal incapacity rests on the prosecution or the state to rebut the defense. In other words, the accused will state their circumstances, explain what they were going through at the time of the commission of the offense, and so on and so forth. And then, so they are in a way tentatively placing a defense before the court. And because it is the duty of the prosecution to prove beyond reasonable doubt, therefore prosecution must go ahead and rebut that evidence, try to gainsay it as much as possible, so that the doubt, the issue of doubt is eliminated. And then the state must demonstrate that the accused possessed the requisite capacity. So it is entirely the duty of the state to ensure that this requisite capacity is established. Otherwise, the accused will always say, I did not have the requisite capacity. And so the state now carries the burden of saying no, there was. But again, maybe we will talk about that on another issue. Having spoken about criminal capacity as the basis for culpability, and having looked at factors that may exclude fault, we spoke about mental illness, we spoke about youth, and then we spoke about different forms of non-pathological criminal incapacity. We now go on to look at intention. Because once criminal capacity is established, then it must be established whether the accused acted with intention or with negligence. Intention is quite a long and lengthy discussion which we cannot exhaustively do in this video. So I have another video dedicated to intention, as well as another one dedicated to negligence. Please look out for those so that you can have a full picture of what we mean by intention. So what I will do in the current situation is just to give an introductory outline of what we mean by intention and how it affects culpability. Intention, also known as dollars, is an integral element of culpability. I've already said that. So a person acts intentionally or intentionally causes a prohibited result if he wills a result, while aware that the act of the circumstances in which the result takes place accords with the definitional elements of a crime, and that it is unlawful. Intention consists of both the cognitive element and the cognitive element. There are different types of intention. Like I have already said, we can't go into detail about these. We have direct intention, or what is called the dolus directus, and then we have an indirect intention, which is dolus indirectus, and then we have the dolus eventualis. So the finer details about each one of these will be discussed, as I have said, have already been discussed in another video rather. So just take note of the fact that intention gets excluded by mistake. So when a mistake, maybe find that the accused has been laboring under a mistake or a misapprehension of some kind, then intention gets eliminated. Take note of that. So mistake is actually excluded by, rather culpability is excluded by mistake, I've already said, particularly with reference to intention. And we are saying mistakes which nullify intention also conform to certain characteristics. It's not necessary for the mistake to be reasonable. Whether it's a reasonable or unreasonable mistake, it would still be sufficient to exclude culpability. And then the mistake can be classified either as material or non-material mistake. Again, this is very important to take note of, but we can't complete it here exhaustively. So we are saying it may be a mistake that relates to a chain of causation. Again, something very, very essential to understand. And then a perpetrator may be mistaken regarding the unlawfulness of his or her conduct. So those are some of the things to think about in respect of intention, rather in respect of mistake. And then thinking about negligence. A person acts in negligence if a reasonable person in the same circumstances would have foreseen the possibility that particular circumstances might exist, or his conduct would cause a particular result. And then it still acts with negligence. Acts in negligence when a reasonable person in the same circumstances would have taken steps to guard against the possibility. But the accused person did not conduct herself or himself according to that appreciation. So he was not reasonable. In other words, he fails to satisfy the reasonable man or reasonable person test, what they call in Latin the diligence paterfamilias. That's a reasonable man's test. And this test will be discussed in detail in the video on negligence, as I have already highlighted. But suffice to say that if one acts, if a reasonable person in the circumstances would have understood or seen that a possibility of harm would arise, and one still goes ahead and acts contrary to what a reasonable person would have done, and then we are saying here that it's an act of negligence. Failure to conduct yourself in terms of what is expected of a reasonable person is actually a show of negligence on your part. Intoxication plays a very important role too. Sometimes it is sufficient to exclude culpability, but there's no straightforward rule here on the role of intoxication. But at least it can be a ground, as was shown in the S versus Shretian case of 1981. Provocation is also a basis. As you can see, intoxication and provocation would still be classifiable under the non-pathological criminal incapacity. Remember, we discussed that one above. If you have missed it, just scroll back and have a look at it. So intoxication and provocation are also very important parts. These are kind of defenses that can exclude culpability. Um, Maybe last but not least, it's very important to understand that there is what we call strict liability offenses. As a general rule, culpability is required in order to establish liability in all all common law crimes. So in crimes like murder, in crimes like theft, in, in crimes like arson, in crimes like what's this one on overthrowing the state, sedition, and all those different common law crimes, you find that culpability is a very essential element. You can't, a person cannot be convicted if they are not at fault. Then, so we're saying the law sometimes makes provision for strict liability in statutory crimes. What we mean by strict liability, we are saying those are instances whereby an accused can still be convicted even if fault or culpability on his party has not been established. That courts, statutes may have this kind of approach where they adopt strict liability, just maybe to discourage a certain kind of action. So the courts, rather the legislation then goes on to introduce crimes where it doesn't matter whether one acted with intention or with negligence. But that's the subject of another discussion. It is important just to understand that there are such instances where a statute can dispense with what you call this strict, you can dispense with liability, can dispense with culpability. The examples are, we have spoken about statutory crimes where the legislature creates such crimes, excluding fault. And then we have vicarious liability. Vicarious liability involves prosecution of corporate bodies and associations of persons. Remember, a corporate body is a company. It's just a kind of an association of persons. It's a juristic person, okay, which is not capable of maybe exercising intention or maybe negligence, but of course it has been said that they do possess that. And then there's the erstwhile application of the versare in re illicita principle, which said to say that when somebody goes out to do wrong, everything that follows thereafter is attributable to their initial initial action. So in other words, somebody ends up getting convicted even in instances where they acted without the requisite culpability. Now, maybe just a point to ponder and think about. In terms of the current constitution, particularly section 35, 3H, on the presumption of innocence, one would wonder whether these strict liability offenses still have a place in the current constitutional dispensation. Because if you are going to find somebody guilty of an offense, even where they did not act with fault, somehow it is a violation of the presumption of innocence. I wonder if it is sustainable. Maybe we'll talk about it in another point, but I would like you just to keep thinking about that one, because it's very, very critical to our understanding of the current constitutional dispensation. Thank you very much for having been part of this video. It covered a lot, and it made promises about a lot else that is covered in other videos, but maybe just by way of highlighting. So the video began by explaining the concept of culpability, explaining the relationships between the culpability and lawfulness, and then also explaining and canvassing the relationship between criminal capacity and culpability. It went on to explore the three defenses of criminal incapacity, namely mental illness, youth, and non-pathological criminal incapacity. It went on to define the concept of mental illness in terms of Section 78, as well as non-pathological criminal incapacity. And then the two forms of culpability, namely intention and negligence, were unveiled and briefly discussed. And then lastly, it highlighted the nature of the strict liability offenses in the context of the factors that shape them, looking at the relationship that strict liability has with the current constitution, whether it will stand the test. And then thank you very much for being part of this presentation. Look out for more of my videos dealing with intention and negligence. My name is Dr. Philani L Ndlovu. I thank you for being part of this. I look forward to more engagements with you. Remember to follow me and write to me at iclassvirtual@gmail.com. Thank you. Good night.